Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a case that is currently pending petition before the United States Supreme Court that is candidly a huge case. Now, it may not be huge to you, but it is going to be huge to somebody you know, maybe even a family member, somebody you care about greatly. But it has to do with the fact that some people, when they're in their younger years, make mistakes and they get convicted of crimes. And sometimes those crimes are felonies. What we're going to talk about is the restriction of Second Amendment rights on those that have been convicted a long time ago of a nonviolent felony. It is an issue that the courts cannot agree on. There is a big petition before the United States Supreme Court, and it really is an important issue that needs to be resolved, and we'll explain why in just a moment. So today, let's spend a few minutes and let's talk about the huge gun case before the Supreme Court that no one is talking about. Okay, America, we are talking about a challenge to a federal law that has been a big problem for a lot of people. And let me explain what I'm talking about. The statute what we're talking about today is 18 United States Code Section 922G1. This federally prohibits any individual who's been convicted of a crime in which they could have served more than a year in jail from possessing a firearm. This includes all felonies, even non-violent felonies. Now, we don't talk about it on the channel a lot, but over at Washington Gun Law, we do a lot of firearm restoration work for folks here in Washington State. And we get calls every week from people who candidly, what they have on their record, there's no coming back from, okay? But we get way more calls in a given week from people who, yeah, they did something regrettable 20, 30 years ago, but should they be disarmed for their entire life for that one-time mistake? The answer obviously is no. They've served their debt to society, and now there's an opportunity for them to restore their rights, except that there is all of these prohibitions, sometimes on the state level, in this case on the federal level, that precludes them from doing that. The case we're talking about today is Zirka v. Bondi. It comes before the United States Supreme Court out of an unsuccessful appeal before the Second Circuit Court of Appeals. Now, just to give you an idea, what is the issue in this case? Whether the Second Amendment permits the government to disarm an American citizen because he has been convicted of a non-violent fraud offense. The plaintiff in this case, Mr. Zherka, pled guilty in 2015 to a charge of conspiracy to make a false statement to a bank and to sign and file a false federal income tax return in violation of 18 United States Code Section 371. A nonviolent offense of which he was sentenced to 37 months in prison. Then, on September 11th of 2020, he filed this appeal. So I want you to know that here we are nearly at the end of 2025, and the case just now sits at the doorsteps of the United States Supreme Court. Now, obviously, since Mr. Zirka is the petitioner, we know how things went at the Second Circuit. The Second Circuit found absolutely no constitutional deficiency as applied to 18 United States Code Section 922G1. Petition to Supreme Court is filed, and away we go. Now, here's the big reason why this case is very enticing to the Supreme Court and why we're kind of geeking out on it here at Washington Gun Law. Much like the issue revolving 18, 19, and 20-year-olds, the circuits are all over the board on this one, okay? There is a significant circuit split. The circuits that have found that there's absolutely no constitutional deficiency as applied or on its face with this statute include the Second Circuit, the 10th Circuit, the 8th Circuit, the 4th Circuit, and the 11th Circuit. But at least 3 circuits have found constitutional deficiencies with this law, including the 3rd Circuit, the 5th Circuit, and the 6th Circuit. Why this case? I mean, this isn't the first time this issue has been before the United States Supreme Court. Of course not. Well, I think the petitioners correctly point out this case presents an important and recurring question impacting the fundamental rights of thousands of Americans on which there is a well-defined split among 9 courts of appeals. Is the federal law generally prohibiting firearm acquisition and possession by individuals who have been convicted of an offense punishable by over a year of imprisonment susceptible to as-applied challenges under the Second Amendment? And then in describing this huge circuit split that exists, the petitioners point out the Second Circuit below, along with 5 of its sister courts, held the answer is no. But 3 courts of appeals have held precisely the opposite. Now, one of the big reasons the petitioners urged the Supreme Court to take this case is that unlike many of the circuits here who just completely got all over the board and went somewhere completely off the reservation in upholding this law, the Second Circuit purported to apply the Bruen standard, but then, of course, either misapplied it accidentally or possibly intentionally. So the petitioners have raised the point, this case provides a good vehicle for this court to definitively resolve whether Section 922G1 is susceptible to as-applied challenges, because unlike many of the courts that have come out the wrong way on this issue, the panel below attempted to apply Bruen. The ways in which it erred in doing so are representative of other errors the lower courts have made and on which this court's guidance is critically important. Now, in a nutshell, I want you to know that all gun laws only do one of three things, okay? They restrict people, places, or things. Now, when we're talking about people, when we're talking about places, there is at least a plausible argument that, there is an historical inquiry that needs to be done. When it comes to things, such as firearms and magazines, we don't even need to do that historical inquiry. We already know if they're in common use, they can't be banned. The only thing that can be banned is dangerous and unusual. But when we go into the history, that's when this can occur.
You got Rahimi'd.
And obviously the proponents of these types of laws will say, well, these are much more modern societal concerns. Are they though? Well, consider what the petitioners put here. There is a second critical error in the Second Circuit's mode of analysis. Even assuming arguendo that there is some meaningful distinction between the type of analysis Bruen requires in cases involving unprecedented societal changes and those that do not, the existence of violent crime, even violent crime with firearms, cannot support loosening the analysis at all from where it stood in Heller or Bruen. Now remember, when we get into the history though, that's when this more nuanced approach due to modern societal concerns never contemplated by the founders can be used to allow a court to go completely off the beaten path. And one of the justifications they will use frequently is, well, this is all about saving lives. This is all about dangerousness. And we already know through other cases that this Supreme Court has made a big distinction between those that are dangerous versus those that were merely irresponsible. The petitioners address it this way. While history suggests that those whose convictions actually demonstrate dangerousness, like those who have behaved violently or who participate in the drug trade, mere conviction of a fraud offense does not demonstrate any proclivity for violence, and yet a person suffering such a conviction is faced with the substantial threat of violence from those who perpetuate the gun violence problem. So is there a historical tradition of disarming individuals that we have deemed to be dangerous? There absolutely, positively is, and there really is no disputing that whatsoever. But is there a historical tradition of banning all felons? Because felonies encapsulate all sorts of offenses, some of which absolutely demonstrate dangerous and threatening activity. But many others do not, such as what the petitioner was convicted of here. And as the petitioners put it, the fact of the matter is that neither the history of felony punishment nor those unadopted constitutional proposals demonstrates anything like a tradition of disarming all felons, much less all individuals convicted of a crime punishable by over a year in prison. The Second Circuit did not purport to find otherwise. Now, one of the arguments that was made by the United States Department of Justice is, hey, listen, we're refunding 18 United States Code 925 sub C, so he can go ahead and get his rights restored. Does that, moot the problem? Does that solve the problem? Well, not according to the petitioners, and I tend to agree with it, because they put it, Section 925C permits a person who is disqualified under Section 922G1 to make application to the Attorney General for relief, which the Attorney General may grant. So yeah, that's not going to moot the issue. That's not going to solve the problem, because the problem here is there a historical tradition of allowing people like Zirka to be disarmed? That's the issue here. It's the constitutionality of 18 United States Code Section 922G1. Ultimately, the petitioners, in trying to encourage not only the court to take this issue, but maybe to have the United States Department of Justice join in and actually assist in recommending this petition be accepted, wrote, in an ordinary case, a clear divide over the constitutionality of such an important federal statute would unquestionably merit this court's attention. Indeed, the government might well be expected to join petitioners in seeking review, as it has done with respect to this issue in the past. Okay, listen, this is a huge petition. This is an issue that absolutely positively needs to be resolved, and one that I would hope the United States Department of Justice would actually join and ask the court to also accept review of it. The case, once again, is Zirka v. Bondi. We're going to link up the petition down below so that you can geek out on it for yourself and you don't have to take our word for it. Now, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.